Well, hello. I'm hoping if anyone's in the chat, if you can just give me a sound check, I would greatly appreciate. Hey, Shill. Hey, Wanda. Yeah. Wanda, Shill, if you could just give me a sound check before you run off, that'd be great. Or Wanda, if you can hear me, please. I want to make sure you shouldn't hear anything from the other side yet because they don't have the mics on. Should have been a little bit of back there. Okay. Nope, just me. You just hear me, right? Because they don't have sound right now going on. From what I can tell, the sites that I'm on, like they still don't have the mic in the courtroom yet. It's only the announcers on the other streams. So hopefully, once it comes to them actually the judge speaking and all, we will get a good sound then. But you can hear me, so that's a good sign, right? I always wonder what they're saying. I really do. Well, this we can't know. This is not what the public, unless you're in the actual courtroom and maybe overhear it. Okay. Thank you both, Wanda and Shill, for the sound check. This was last minute on my part. Basically, I can tell you that it's not going to be too exciting, but I do want to document it. Judge Toal will be actually setting down procedures and what's to be expected and dealing with anything in regards to discovery before the evidentiary hearing that is going to be at the end of the month, or she's already scheduled, which is planned to be 3 days, where they will bring forth everything to see. She will hear all of the evidence in regards to whether or not a retrial is actually warranted for Alex Murdaugh for his murder conviction. She's got all the motions on file. For those of you in my Discord, I did put a great link out from Fitz News. Has got a wonderful recap of all of the motions that were put forward by both the state and Alex Murdaugh's defense team of Harpoolian and Griffin. Uh, all of their motions back and forth, the witness list. Um, Judge Newman's on the witness list. Crichton Waters on the witness list. David Owens is on the witness list. There's quite a few jurors. There's 4 jurors on the witness list from the defense. Um, of course, there's the egg lady in juror number 630 and 285. A few others. Alex does not look too worse for wear currently. Mm. He doesn't look as shaky. Remember, even if he does get this retrial, he's probably not going to get out of jail. He did actually confess to many of those financial crimes, and based on the sentencing, he's got quite some time to stay in there. That's going to stay. That doesn't have anything to do with this trial. This is only for the murder conviction. I think it's good timing for the actual attorneys to get with their client here. They can get some stuff done actually while they're waiting. I'm sorry. Oh, Wanda, I'm sorry you're so stressed. I'm just reading back on messages. Mm, But it is good to see you. I'm sorry that you're stressed. Looking for housing is tough, especially like on the East Coast here. It's winter. I don't know where you are, but it's cold and nasty. Ugh. It's only about 30 here today, and as you can hear on my voice, I still recovering from a horrible, I guess it's a head cold with sinuses and all involved, and feels respiratory involved. Really havoc on the voice and really making me quite tired. Not to mention I can't breathe too good. All of that. I don't know what this delay is. Nope, they're all still not showing any sound coming out of the courtroom. Just did another double check. Okay. I think for now, since it's kind of quiet in here, I'm gonna remove myself from the screen. You'll hear me occasionally say something, but I want to just let it play through. I want to record this for prosperity. We can talk in the chat. Yeah. Hey Liam, it's good to see you. I was just saying, Liam, as long as when they start to play it, we do a sound check. I'm going to take my little picture off the screen here, I think, and just let this play fall through. They should be starting soon. Or let it play through. We could just talk in the chat in the meantime, but I want to record it for prosperity, you know. Hey, Rocky Couch. All right, so let me make it big screen. There we go. Okay, I'm gonna do a typing test with the mic open. Okay, I want you guys to tell me uh, with my filter on if you can still hear the key clicks. Okay, could you help me test that? Thank you. Mhm. Hi, Michael. Oh, you didn't hear the clicks? Awesome. I'm gonna wait a few minutes to make sure that there wasn't a delay. Thank you, Liam. Welcome, Michael. StreamYards did this really neat thing for me and put a background filter in that's supposed to get rid of a lot of background noise, which has helped with keyboard clicks or with me typing in chat, you know. Good day, Armageddon. How are you? I hope everyone is well. I did put up a community tab this morning early because there is so much going on today. Sarah Boone already had her hearing, like 45 minutes ago, was she was scheduled for 9 a.m. in Florida. We're going to find out if she gets granted that continuance. I do expect that that's going to go through. Hopefully, I will get some recording on that for you for later on. We've also got the start of the E. Jean Carroll second trial, or its jury selection starts today in New York, in Manhattan. Mm. In Staten Island, we've got a hearing for Rex Harriman. There's status hearing going up, something about discovery. Gonna go in there. Thank you so much for the super sticker there, Armageddon's Fire. Thank you so much. We appreciate it. That's going to go right to the Potato Fund, which I tell you is my new technology fund, which is doing quite well right now. Thankfully, to a lot of help from a lot of subscribers and members in the Patreons for the whole year of 2023. We are building a beast of a computer in the next couple of months. And then we're just going to have to get it shipped, and we should be good to go. We should be good to go by the end of the quarter, actually. I'm hoping. We'll see. I have to send some parts, but it's exciting. It's exciting. But on the updates, again, we also have a hearing in Scientology, in Leah Remini's lawsuit against Scientology in the civil case. There were anti-SLAPP motions going through, Scientology pushing back hard on Leah Remini's amended complaint, first complaint and amended complaint. And the judge actually did a little bit of like pre-discussing on it. So we kind of know he's gonna like do part of it, but not all of it. It just looks like that. But that's gonna be an interesting update this week too, because there's a lot going on there. Because that judge was quite annoyed with both sides with all the paper filing. He's the one who said enough is enough. Okay. We also have an update on the TikTok psychic Schofield versus Gilead this week. Got some updates for you on that. And also on Brian Koberger. Remember the DNA evidence. Yeah. Remember the judge wanted all of the information in regards to the IgG from the state, and he's going to look at everything to see what the defense really might find pertinent or not, and whether it should be all turned over, because there's been a fight back and forth in regards to what they should have to send out or not. Oh, thank you, Rocket Couch. You heard it just a little bit? Okay. The thud of the fingers rather than the actual click. Well, this seems to have helped with both. Okay, thank you. Yeah, if I was talking, but sometimes I'll be typing to you while I wanted to double check once they start talking, because I don't want to interfere with what they're saying. Like if I'm typing to you guys in the chat. That's why I was just double checking. I could use a recommendation on a new keyboard though, guys. I'm looking for a whisper quiet, like you know, the best technology I can right now, but I'll still be running Windows 10 on my beast for a while until I don't want to go right to 11 right away. So if you guys, any of you have a recommendation for a really quiet, comfortable keyboard, I'm not really, it doesn't matter if it's wireless. I prefer wireless because I move around the room a lot, but I could do USB. Oh, thank you. Thanks. Nowhere near. Oh, that's good. Oh, okay. Good. I like how they say 9:30. And look at all this. This is going to be trimmed. Our chat is going to end up disappearing because this actually recording is going to end up getting trimmed down. We're already on 15 minutes with no hearing here. You know what could be going on? The judge may not want to talk to jury members or things like that, like in public for disclosure and stuff like that. Or they're dealing, with stuff on the sidebar, or the judge just isn't ready. But I would expect, even when we get to the evidentiary hearing, that a lot of it's going to be done in camera, which is going to be like in chambers, private, with the jurors, and then it's for the judge, because the judge gets to decide here. Okay, not a secondary jury. The judge alone in this evidentiary hearing, they're going to want to hear everything. But we're not exactly, even if it is supposed to be uh, recorded, just like it is now. They have Law and Crime in Fitz News is on the list in several news organizations. I'm pulling the feed from a news organization, which is usually very friendly, was during the Murdaugh trial in the past, or with allowings, people to record it, as long as we were doing commentary and giving them full credit, which of course we will. Um, they just want to get their feeds and all up and running, you know. Who this new judge is? Judge Toal is a retired Supreme Court judge. Okay. She was pulled back in for this. She has quite the reputation of being very independent thinking, um, very determined. She's in control of her court. She's got quite the reputation. However, I have listened to quite a few law channels in regards to how many jury tampering cases that she has actually weighed in on, considering she was on the Supreme Court. They would have got there for the state, in South Carolina. She would have heard them. There were not really a few. There were a few, but nothing like this that could actually be compared to. And she seemed quite even tempered on procedure, yes, and she also in ramifications of of the trickle down. So I think she's a good solid choice for balance here. I think this could actually go either way. uh I do think she has a reputation of being well schooled in law. Like, nothing they're going to write or throw at her will be news to her. That is what people are reporting, that she is so educated on the law, in such an information source in her opinions and all, that they're not going to be able to throw anything at her she hasn't already anticipated, which is why, again, I say she's like probably an excellent choice for this. Okay. um I think she's going to be able to look at, of course, anyone in that position has to be able to look at it as a much bigger thing than just justice for Alex Murdaugh, to make sure he got a fair trial. He could have actually gotten his fair trial. It depends on whether or not the statements that Becky made were made all the time about all the witnesses, this, that, and everything. They weren't any big deal, or did she actually coached anyone? I mean, they actually have to prove. Well, remember that the policies that Judge Newman had in place prior, where he actually talked to the jury all the time, and they filled out questionnaires for him constantly on events, and they're going to be able to pull all that in too, and the judge is going to be able to look at that too, and see that the one person that seems to think that Becky, who had the most contact with Becky Hill, actually said that, actually put down in writing in their affidavit, that nothing Becky Hill did changed their mind about anything, that their mind was already made up. Um, that's a bold statement. Of course, I don't know whether the attorneys are going to get to question these juror members, but that's not going to happen today. Today is a procedural hearing, in like a status and procedural. They're going to go over to make sure. Well, the defense says that the state hasn't turned over everything they need to prove their case, but the defense is the one bringing the accusations, and I don't know what they think. Like, I mean, people have cooperated with interviews, this, that, and the other thing. Um, we'll see. We'll see what that's all about. That should be public. There shouldn't be anything private about that. Anything to do about particular jurors that wanted to keep themselves anonymous, we may not hear. But we'll see. You know. But really, I wanted to record this for Prosperity once because we get to see Alex Murdaugh. Okay, we're going to get to see the attorneys again, and I want to see how this judge is. I want to get ready for the end of the month. I wanted to just see her in action. These are not, the most exciting kind of hearings. The one at the end of the month is going to be much more. Okay. Well, we could not get a live feed on Sarah Boone, or I would have been here earlier with that. I will probably have footage by the end of the night from somewhere, but I'm pretty sure that's just going to be a continuance. This is so interesting to me that this is getting like so delayed. I don't know if they're working on things together. The judges, I mean the lawyers, could be. Because this judge also, like, she don't play around. You don't waste her time. She may have asked them both, to make sure that they met and squared some stuff out before she had to deal with it. Like, they should come to some kind of an agreement, especially on information that's to be shared back and forth. This is when she's going to set up all the dates on when things happen to happen. The last time you could put on a person in a witness list, this and the other thing. All of that. She's going to put the dates on it there. But we already know when that evidentiary hearing is, if it's going to be necessary based on what happens today. This is where she says they're actually going to do it, like go through. Which, because it's already on the calendar, I'm thinking it's pretty much given. I can't imagine why not. Mm-hmm. Yeah, Carrie Ann, he does look a little more relieved, doesn't he? Like, he's not shaking as much. He doesn't look as angry. But then again, he's just doing some paperwork and having a nice conversation with one of the law clerks, Liam, did you have any more specific questions about Judge Toal? I mean, Judge Toal, like, she was brought in special from retirement through the roster, which happens often from the Supreme Court. I mean, she retired from the Supreme Court. So she does do these type of specialty cases. She's on the roster for it. She'll come out of retirement for it, but she's not getting cases on a regular. Judge Newman could probably do the same thing if necessary, Yeah, I would imagine he's completely detoxed by now, right, Liam? Unless he can get anything in there. Okay, they're pulling back. Oh, attorney's coming in. We all know them. That would be Dick Hartpoolian, Jim Griffin, and it looks like Philip Barber joining Alex at the table, which means we're probably going to be starting soon. So I hope I can get another sound check. The attorneys don't seem to have changed much. That is Philip Barber. Remember, he was the tech guy with the cell phones and stuff, right? It's nice to see you, Carrie Ann. Okay, they came in, and Jim looks not as hopeful as Murdaugh did prior to them getting in there. I don't know what that means. Yeah, today's will be a little bit not as exciting, Carrie Ann. It's going to be procedural. She'll be setting the dates and the requirements for going forward with the evidentiary at the end of the month. She'll say how it will happen, how she will, what she will allow and what she won't. And when I say she, I mean Judge Toal. It seems like whatever has caused the hearing to be a little bit delayed is what they're discussing. Yeah. I think, well, maybe the judge has put a bee in their ear. I don't believe this judge. Actually, Harpoulian mentioned this judge with great respect several times after they made their filings. So I don't know what kind of a relationship he has there, but this judge does have a reputation for not messing around at all. I think he got some happy pills before he arrived. Who do you mean, Murdaugh? Perhaps, but the lawyers don't look as confident. They just I don't think Griffin, who is usually in charge of all of the shall we say, like pulling forward the legal requirement there in the knowing the case law and pulling out cases to prove his points and stuff like that. He looks a little flustered actually all of a sudden. I don't know. Hmm. I don't know what it is about his defense team. They always look like they're doing stuff last minute at their table. At least Jim Griffin does. He's always doing something out, filing something. Hey, looks like A.G. Wilson. Okay. Crichton Waters, is that? Yes. I thought he was on the witness list, but I guess he's allowed to still. And John James. Remember John James? He did a lot of the financial. Yes, he very young to the department. One of the youngest AGs there. And I forget the senior guy's name, but I'm glad he's there too. I will get it for you. I don't hear anything though. Why am I not hearing anything? Okay. I'm going to bring it down and bring it back up real quick. Okay, it says I'm sharing the audio tab. I don't know. Yeah, there's audio and I'm not getting it through this feed and I don't know why. Okay, I'm going to bring up a different feed. Okay, let me try to refresh this feed first. Why is there no audio? Oh, okay, so I don't know why it's not. Okay, I'm going to bring up another feed. I'll probably bring up Fitz News because they're pretty friendly because we want to get this. We definitely want to get this all on file. So, Oh no, that's my own. Hold on. Wait. Here we go. Hold on.
Were filed by defendant Murdaugh's attorneys on March the 9th, 2023 with the South Carolina Court of Appeals. The transcript in this very lengthy trial took several months to produce, even in draft form. Before the attorneys received the final transcript, on September the 5th, 2023, defendant filed with the Court of Appeals a motion to suspend his appeal and for leave to file a motion for a new trial with accompanying affidavits and transcript experts. After further defense and state filings on October the 17th, 2023, the Court of Appeals granted appellant Murdaugh's motion to suspend the appeal and to remand his case to the circuit court to allow defendant Murdaugh to file a motion for a new trial. On October the 17th, 2023, defendant Murdaugh received the final trial transcript and very shortly thereafter filed a motion for new trial in Colleton County Clerk of Court's office. Subsequently, Judge Clifton Newman recused himself from further proceedings in this matter. On December the 16th, 2023, on December the 18th, 2023, Chief Justice Donald W. Bailey signed an order appointing or directing that the Honorable Jean Hayford Toal, retired Chief Justice of South Carolina, be assigned exclusive jurisdiction for the limited purpose of presiding over defendant's motion for a new trial. I promptly contacted counsel in this case and set deadlines for briefing and arguments of the new trial motions. The new trial motions were set to be argued on January the 23rd, 30th, and 31st of 2024. And after several rounds of pretrial briefs having been submitted to me, I also set today's date for a procedural pre-hearing. Before I begin, may I say that we certainly welcome members of the media, and I thank publicly Attorney Jay Bender for agreeing to be the voluntary media coordinator for this matter, as he did for Judge Clifton Newman on the trial of this matter. Cell phones are normally not permitted at all in our courtrooms, but the press has been allowed to bring in certain cell phones and laptops and electronic devices because of the non-jury nature of this portion of the proceedings. But if any device rings or sounds to receive a call or to receive an email or a message, that device will be confiscated and the owner will be asked to leave the courtroom. So please now, if you haven't already, check your electronic devices and be sure that they will not sound during the time these proceedings take place. Major topics to be covered today have been addressed by me and discussed with counsel in a short pretrial conference in my chambers. And counsel may have certain things that they will put on the record as we proceed through these topics that deal with what should be covered. The first topic is an evidentiary hearing necessary at all? The state took the position the answer to that was no. Obviously, the defendant not. I have set an evidentiary hearing because I felt like we had to have some brackets on the time we would spend on this matter. But I've made no conclusive decisions beyond that on matters affecting the arguments the state makes about the procedural posture of this matter. The next topic would be the burden of proof. Who has the burden of proof in this matter? And what must be shown to meet that burden of proof? And what must then be shown to contest what has been shown and proven? The third topic is procedural defects, most specifically a contention by the state that this motion is untimely because of what was known before a verdict was rendered, accepted, and the jury poll. And finally, we need to discuss witnesses, juror witnesses, the clerk of the court of Compton County has Hill, and other witnesses and exhibits. I note that at least one attorney in the room is an attorney for some of the jurors, and other jurors may have other attorneys. When I get to the portion of this discussion where we talk about specific witnesses, and if I am asked to hear from attorneys for the witnesses, I will at least consider that request. I don't know where we will be at that time in terms of what has been decided, but I will at least inquire about that. To that end, if you have not already, during the first break, be certain that all of you, the lawyers participating at council table, and any other lawyers that feel they may have some interest in the proceedings that would warrant comment by them, please give your cards or information about your contacts to our court reporter, Ms. Harris. With that, Mr. Harper, being your moving party, you may proceed.
If it please the court, Your Honor, you've raised, I assume you want to go in the order in which you just.
I would.
Okay. You've raised a number of legal issues from whether we've waived, a number, I forget the order in which you just took them, but Mr. Griffin is going to address those in seriatim based on what you said just a moment ago as to the witnesses and the jurors. I will be handling that portion of the argument today.
Very good. Ms. Griffin, we'll hear from you now.
Yes, thank you, Your Honor. The first issue that you've asked us to address is an evidentiary hearing necessary? And the answer to that question is very straightforward, is yes, under established case law in the Supreme Court, Fourth Circuit, and the South Carolina Supreme Court under Reamer. A Reamer hearing is absolutely necessary where there has been credible evidence presented that there's been improper third-party contact with the jury prior to their deliberations that frankly, whether it goes to the merits or not, a Reamer hearing is absolutely necessary. And we believe that the Court of Appeals decision in this case contemplated a Reamer hearing. And in a Reamer hearing, evidence is presented as to what outside influences, if any, were brought to bear upon the jury. We have, in our motion for a new trial, submitted affidavits of one deliberating juror, one alternate, and then another affidavit of a witness to an interview of an alternate, and all three statements are consistent, and in that they heard Ms. Hill, the clerk of court, prior to deliberations, and frankly, before the defense put on their case, Ms. Hill instructed, do not be fooled by the defense. That's what the sworn statements say. And secondly, before Mr. Murdaugh took the stand, Ms. Hill advised one deliberating juror and two alternates, at least, watch his demeanor, which is an implication of, he's going to lie. And so then the question becomes, factually, did those contacts happen? And then, we proceed from there as to what the burden of proof is after that. But the threshold, are we entitled to evidentiary hearing? The law is crystal clear that we are.
Thank you, sir. Mr. Waters, to the state.
Thank you, Your Honor. May it please the court. Your Honor, obviously, you've addressed the issue of whether an evidentiary hearing is necessary. The state certainly understands that. It is incumbent upon us, though, based on the law, to preserve our arguments as to procedural bar, and those are twofold. And the first one, of course, is that a motion for a new trial must be filed within 10 days of the verdict, unless there's after discovered evidence. And I think an initial inquiry that needs to be determined is when the defense first learned of these particular allegations. In conversations with the defense, and they said they're going to give me an answer, that they may have had conversations with juror 785 prior to her being represented, which was only a couple days after trial. So if that is the case and they were aware of these allegations, then we would want to argue to Your Honor and preserve the issue that this is not after discovered evidence and that there's a procedural bar in that regard. Secondly, we made the argument that the affidavits on their face, the only deliberating juror indicated, and that's 630, in that affidavit only said that she voted guilty. She had questions, but voted guilty because she felt pressured by other jurors. And of course, the law is crystal clear in multiple cases that sort of internal debate, it's actually in Rule 606B, that's not any sort of misconduct or anything that is a appropriate venue or mechanism in order to attack the verdict. So for that reason, we've argued that their showing in their motion for a new trial is insufficient based on the case law for an evidentiary hearing, because there is on its face no sufficient allegation of prejudice. That being said, of course, we fully understand and expect the evidentiary hearing will go forward, and we'll be happy to address burden of proof after the defense makes their arguments.
Very good. With respect to, well, Mr. Griffin, anything in reply?
Your Honor, it does not appear that the state, takes a position contrary that a rumor hearing is required. That they're arguing that we had sort of waived the right to that hearing. There's no evidence in the record of that. I can assure the court we did not know of this information within 10 days after the trial, and when we learned of it, we promptly acted.
Well, in conversations with Mr. Harpootli and Mr. Griffin, they were going to actually look into that and look at their paralegals notes. So I fully rely on and trust the defense to give me a fair answer to that question. And then again, if there's an issue to be raised, we would raise that. We're not conceding anything. We just wanted to preserve our procedural issues.
I don't think we need to go back and forth many times about this. I think I understand your position. Here's my position on the matter. First of all, I am not conducting a rumor hearing. Rumor is a 1954 decision of the United States Supreme Court that deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge, State versus Green. And the Green decision specifically says that rumor is not the guidance that South Carolina trial judges should look to in conducting hearings on after discovered evidence. Now that says nothing about what the burden of proof should be, and I don't intend to say anything thereby, but I do intend to tell you right away that I will be relying on South Carolina's jurisprudence and South Carolina's jurisprudence specifically on what must be proved in a hearing of this nature and who bears the burden of that proof. All right. And that leads to the very next topic that we will now take up, which is the burden of proof. Mr. Griffin?
Yes, Your Honor. As we cited in our papers, we believe that the controlling case in this instance, based on the scope of conduct as alleged, and that is conduct of a court official, here the clerk of court, having communication with the jury about the substance or the merits of the case, that the standard to be applied is not Green, because Green, Judge Kitzer says that the contact by the bailiff was about a procedural issue, not about the merits of the case. Here we're dealing specifically with the merits of the case, and the Court of Appeals decision in State v. Cameron, we believe, is the controlling standard. And in State v. Cameron, and that was decided in 1993, and the court says, in citing Holmes v. United States, which is a Fourth Circuit opinion, says in this case there was a private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Now, we strongly believe that is the standard. Is the question of, was the subject matter of the communication harmless, and that it could not have affected the verdict? And we are, that's our position on the standard. Your Honor, if Your Honor looks to a different standard, we believe that State v. Green, the measure of State v. Green, you can't look just at Justice Kittredge's opinion. You have to look, because he complimented the Court of Appeals decision. And the Court of Appeals decision absolutely applied the Reamer standard of the burden of production is on the defendant, but when the defendant produces evidence of a substantive communication to the jury by any third party, that's what Reamer is, by any third party, that then there's a presumption of bias, and that the state then has to overcome that presumption, produce strong, clear, and convincing evidence that it was harmless. And that was the standard that the Court of Appeals applied to State v. Green. And in State v. Green, the Court of Appeals says that this is the standard of the Fourth Circuit, and we follow the Fourth Circuit law in this area. Now, Justice Kittredge says that the communication by the bailiff, which essentially said, if you're deadlocked, which they never were and never became deadlocked, then the judge may ask you to stay locked. I mean, that was a communication by the bailiff in Green, and Justice Kittredge said that did not go to the merits of the case. Justice Kittredge didn't throw out the Reamer presumption standard in State v. Green, Your Honor. And it's important, the Court of Appeals decision, looking to the Fourth Circuit, because, as Your Honor knows, this case, and I would encourage the court to look at the Holmes decision out of the Fourth Circuit, which we cite, which applies Reamer. It applied Reamer in a habeas corpus case when they said Reamer is the clearly established law in the Fourth Circuit. And it vacated a death penalty conviction out of North Carolina because the North Carolina courts did not follow Reamer. And so the Court of Appeals decision in Green says we look to Reamer. Justice Kittredge says, we're not going to apply the Reamer presumption here because it didn't go to the merits. What we have in this case, and what we have, presented through proffer on the affidavits, something that goes to the heart of the merits. It's the defense. It's the credibility of the defendant's testimony. And so we do have the burden of production, but we do believe that the standard in Cameron is we just have to show that the subject matter of the communication, that it was material to the case, and that then the burden shifts to the defendant to prove that it was harmless. The burden shifts to the state to prove it was harmless.
Thank you, sir.
That's what we believe the standard is.
Mr. Waters?
Sorry, Your Honor, and I'm going to walk through some of the cases in South Carolina that address this issue. But as Your Honor is aware, of course, when we deal with these issues, we have two types. We have internal misconduct, and our courts have been reluctant. Rule 606 says this as well, to delve into that unless there are concerns of fundamental fairness, like racism and things like that. And then there's external allegations of external influence and that sort of thing. And that's what we're dealing with here today. And to quote State v. Grovenstein, which is a 1999 case of the state Supreme Court, it cites Aldrin Kelly and says, we have consistently held the defendant must prove prejudice in these sorts of claims. And if we walk through all of the case law, our court has been very careful, and as much said so in Aldred, which was an internal case, to sync the analysis and the standards between those two, and have consistently held that the defendant has to show prejudice. It's their burden to do so. In Blake in 1992, the court held, don't presume prejudice. And the test, of course, was whether or not the verdict was solely the product of honest deliberation or whether it was the product of outside influence. We go over to State v. Kelly. Of course, Your Honor concurred with Chief Justice Finney's dissent in that case, but in that case, there was a pamphlet in the grand jury room. Clearly, an external influence was alleged there. And ultimately, in that case, the court held that the defendant failed to show prejudice from that particular external influence. In State v. Grovenstein, in this instance, it was clearly external. There was an alternate who was present in the jury room and even took a preliminary vote with the jurors. So clearly an external influence, far more than's even alleged in this case. That juror was removed, curative instruction was given, but ultimately the court was very clear that we have consistently held the defendant must prove prejudice, again, the burden being on the defendant. In Bryant, this was a capital case, one that I argued way back when. And in that instance, there was a police investigation, background investigation into death qualified jurors in the capital case. Clearly external. The trial court conducted an inquiry with questions submitted by the parties as well, and ultimately noted that it was the defendant's burden to prove actual bias on the part of the jury. In State versus Pittman, another case that I argued before, Your Honor, in that particular case, there was a juror who had a conversation with his wife and with the bartender. And ultimately, again, the court held that the defendant failed to meet the burden of prejudice because the wife's comment was the defendant was not guilty, and the comment to the bartender took place after deliberations had begun. And then, of course, in Green in 2020, Your Honor just commented on that, and the court clearly held that the Rimmer presumption of prejudice doesn't apply here. And then, of course, went on to note that the defendant bears the burden of proving prejudice. And Cameron is a case that they rely on a lot. And I would say this about Cameron, and that Cameron, of course, goes on to say that the mere fact of any official communication does not necessarily mean that the jury was prejudiced, and went on again to do a prejudice analysis and a harmless error analysis. Covington is a Court of Appeals case from 2000. In this particular case, there were jurors who supposedly knew the defendant and knew some external information about whether or not he had had previous difficulties with his wife and that sort of thing. Clearly external information. And again, the court held that the defendant failed to show prejudice. So the case law in South Carolina, both from our state Supreme Court as well as our state Court of Appeals, it's clear, it's in sync, it's uniform, that is the defendant's burden to show prejudice. And that's, of course, only after there's a determination that any sort of extraneous influence occurred. And that would be the state's position, that it is the defendant's burden. And again, we can address at the appropriate time what the state's position is as to the order in which the evidentiary hearing should go.
Thank you, sir. Mr. Griffin, in reply?
Yes, Your Honor, there is a tremendous difference in the law as to how the court analyzes juror misconduct, as in Kelly, where the juror reaches out to her pastor, gets a pamphlet, brings it into the jury room, and that was found during the course of the trial. The trial judge removed the juror who had gotten a pamphlet. Board had the cases that he cited and they state relies upon are juror misconduct cases. Not unauthorized third-party communication that goes to the heart of the Sixth Amendment, right by a defendant to confront his accuser, to cross-examine witnesses who present evidence. And when a third party makes an improper contact with the deliberating jury before they deliberate, that falls at the heart of the Sixth Amendment, which is a different animal altogether than where a juror engaged in misconduct. And that's where you get to Cameron. That's where you get to Green, which Green says it was a procedural communication, not a marriage communication. And Your Honor, in Bryant, well, I would note, Your Honor, dissented in Kelly, But in Bryant, I mean, no jurors were interviewed, as best we could tell by the record. But in Bryant, it was a death penalty case. Law enforcement, I believe it was Horry County, were out questioning the jurors' relatives and friends and trying to get their belief as to whether they believe in the death penalty. Apparently, some of that kind of leaked back to one juror, or maybe, but there was no record saying the jurors were prejudiced by that. But the court said that behavior cannot stand, and we find prejudice based on the conduct, not on the juror's testimony. And they didn't use the word presumption, but they found prejudice. And I don't want to get caught up in this issue of do we have to establish prejudice? I think prejudice is established, but the question has to be established. But the question is it presumed under the circumstances? And if it's presumed under the circumstances, what does the state have to rebut it? And so, prejudice is a touchstone, but the question is evidentiary presumption. Here, where there's a third-party communication that goes to the merits of the case, the law is crystal clear that there is a presumption of prejudice, and the state has the burden of proving it's harmless beyond a doubt.
Thank you, sir.
Thank you.
All right. Mr. Waters? I'm not going to go back and forth a million times. If you want to have a short comment and additional thought.
Very short, Your Honor. He said that these were not external influence cases, and every one of them that I listed was, Your Honor. Blake was a bailiff. Kelly was a pamphlet. Again, it was an external piece of information coming in. Grovenstein, it was an alternate. Again, that's an external influence. Bryant was a police investigation. Pittman was a bartender and a wife's comment. Green was a bailiff. And Covington was, evidence that was not admitted at trial that the jurors were aware of. So clearly, all of those were external influence cases, Your Honor. All right.
I do not regard State versus Cameron as the guidance that needs to be used by me in making a determination about this case. It's a Court of Appeals case. Since that case in 1993, there have been several cases, including Green, Oliver, and others, that very specifically talk about this issue of what the burden is on a motion for a new trial on the basis of after discovered evidence that involves tampering or alleged tampering with the jury. All those cases say that prejudice must be proved, not presumed. And it may very well be that is what's going to be shown. But for purposes of what the defendant must show as the case goes forward to the evidentiary hearing, the presumption simply by the contact, which we don't have any sworn evidence about except in the area of one juror at this time. A presumption is not the way to examine this issue, but rather specific evidence about what was said, when it was said, and how it was perceived by the juror is what I believe is required by State versus Green and other cases. And therefore, that is the approach I will take. All right, the next area of inquiry is the procedural argument of the state that this matter was untimely made. Mr. Waters?
Yes, ma'am, Your Honor. And again, we have raised the issue, as I talked about earlier, that we believe that there is at least an inquiry as to a procedural bar, that if the defense was aware of these allegations during the 10 days, then it is not after discovered evidence and the motion is untimely. And additionally, we also, as I previously expressed, have raised the issue that the affidavits on their face are insufficient to put in play an evidentiary hearing. And there are multiple cases that have in the state that have held. I think Yarborough is one of those that have held that where that showing was not made, that the trial court properly denied an evidentiary hearing. So we would just preserve those issues, understanding the court's plan and the procedure that you previously expressed.
All right. Mr. Griffin or Mr. Harpootlian, let me say that I will say to the defense, to the state, I believe that issue needs further exploration, so I am not prepared to rule that this matter is untimely in the least. We're going to have a hearing on this matter, at which time this issue will be further explored. So the state has preserved its position, but you need not argue about that matter at this time.
Thank you, Your Honor.
And now the matter that to me is the heart and soul of what we're doing today is the witnesses, the exhibits, and the procedure needed with respect to the witnesses. And the witnesses, at least, are the jurors and the clerk of court, Ms. Hill. What I'd like each side to explore with me is how those witnesses should be presented, who should present them, and how they should be questioned, and whether there are any brackets or limitations that should be imposed on what these witnesses are asked. And I will begin with the jurors, which is really the heart and soul of the matter. Other witnesses are very secondary to the first issue, which is the jurors themselves. Mr. Harpootlian, you are the moving party, and you may proceed.
Your Honor, we agree all 12 jurors should testify. I think both sides agree, Your Honor, the question of jurors. The only question is, not the only question, but the first question would be, as Your Honor questions these jurors, would you, in all the cases the judge questions the jurors, would you want suggestions from us as to what additional questions after they respond to your questions, that raise additional questions? That's number one. Number two, each one of these jurors, except of the original 12, I think all have been interviewed. Maybe two have not been interviewed by SWED and given statements, recorded statements. The rest have all given recorded statements. And then SWED prepared a memorandum of interview. We have reviewed all these videos and the MOIs, and I can tell the court that the MOIs aren't consistent in many instances with what was said on the video, to the extent that information was left out. Now, if Your Honor is going to be very restrictive and ask, did the court communicate something to you, and did it affect your decision? I guess that's what we're hearing, Your Honor, when you're following State versus Green. If you're going to say that, ask those questions. There's some of these jurors who indicated they heard the court say what the juror that gave the affidavit for us say, and I think they're going to say it didn't affect them, which is fine. If it affected that one juror, we believe that's enough. And that juror has obviously given an affidavit to us. The alternate, which was excused, and we keep calling her the egg lady, but she was also excused. The alternate because she wasn't needed, the egg lady because the judge found that she had contact with people and discussed the case. They further indicated that the court said what we say she said, and we believe they should be examined. We'll be happy to do that, or the court can do that. So there are witnesses, and then we have the court herself. I talked to her lawyer this morning, who indicated she's not made a decision as to whether or not she would assert any constitutional right not to testify, and obviously that would be on a question-by-question basis. Maybe, I don't know, we're not ready to argue what the standard is on the Fifth Amendment. if she does testify, there are literally thousands of emails we furnished last week by Colleton County, some information furnished by SLED this morning and the Attorney General, which might be utilized, I can't say right now what it would or wouldn't, depending on her answer, to impeach, to contradict. So I can't tell you what exhibits it would be or what we would do because I don't know what her answers are going to be. We believe we should be able to examine her as a hostile witness. We should be able to call her as a witness. Because the burden is on us, as Your Honor just enunciated. Now, the only other thing I would say is this. Even if Your Honor determines that a piece of evidence or a question is not admissible for your consideration for purposes of the appellate record, we believe you ought to be able to make a proffer. So it may be that Your Honor allows us to go forward, and then in your decision decide it's not relevant, in your decision decide you didn't consider it, or whatever. But a stop and go is going to elongate that hearing dramatically. And again, since you're the finder of fact, you can decide not what a jury's going to hear, but what it matters to you. So we think that the examination of the court should be wide open, and we think that the exhibits we would use to impeach her, we would attempt to keep it relevant to the specific issues in this case. I mean, her son has been indicted, for instance, her son's been indicted for wiretapping. There seems to be some inference, at least what we read in the papers, we don't have any specific knowledge, that she was aware of that and that wiretapping was in relation to some ethics complaint about her. That's not relevant. We're not going to ask her about it. We're continuing to examine whether or not there is some connection there, and we're investigating that. But at this point, I would tell you that's not where we're going. Where we are going, by way of example, is we have been furnished an email that she got on February 24th from somebody, which was a photo, a screenshot of a looks like a posting on some sort of Facebook page where the ex-husband of a juror, not the egg lady, alleges that his ex-wife has been talking about the case and she is going to vote guilty because she hates men. Now, we know she got it. We know she got it on February 24th, yet on the morning of February 27th, she tells in the chambers, the hearing we were all present at, that she had seen a Facebook page posting by Egway's ex-husband alleging that she was talking about the case and she didn't think he was guilty. That Facebook page has never been produced, and then she produced a Facebook posting, she said, by the Egway's husband. Turns out to be a guy I interviewed in Georgia, apologizing for what he had posted on Friday night, which concerned his wife's aunt meddling in their marriage. I think that's fertile ground for cross-examination. Your Honor may disagree with me, but I still would like to put those items into evidence for the appellate record at the time. The last thing I would say is this. In terms of Your Honor questioning the jurors, we need instructions from you as to whether you want, after you finish with the juror, do you want us to submit questions to you? I doubt you're going to let us question them. How is that process going to work? And will that be done someplace? Will it be done in this courtroom? Will it be done somewhere else? And if the juror is going to be questioned outside of this courtroom, will there be a way for the public to hear what they have to say? Thank you for your indulgence. points out, it's not just what they heard, may have heard from the court, but did any of the other jurors, for instance, Egway, we keep calling her, gave an affidavit indicating Becky said things like, don't be fooled, watch the body language, watch body language testifies, Mr. Murdaugh. Did she relay that to any other jurors? It's not just what, I mean, was it, did it, or did the sitting juror or the alternate in the one other point, in the memorandum of interview, now, the court's private lawyer, Mr. Lewis, objected to any videotaping or audio taping of the court when she was interviewed. But in the memorandum of interview, she, that is, the court indicated she had conversations with the four-lady outside the presence of the rest of the jury about what was going on in the jury room. Obviously, I would cross-examine her on that, but it may be necessary if she testifies to things that are inconsistent in that MOI for us to call the SWED agent that did the interview to corroborate the MOI. The MOI may be introducible in and of itself as an exception to hearsay rule, but I believe it may be necessary for us to call the SWED agent. We're not going to, and Your Honor, we're not, you've indicated that you're not going to want to know any sort of summaries of those interviews by the jurors when we talk back in chambers, or necessarily the MOIs. You want your own fact-finding with the jurors. To the extent that they contradict those, we may put all of that into the record for appellate purposes. And if you want to see those before you have this hearing, we obviously put those. We can put those into the record today, or have those available to you, both the MOIs and the videos. Or I mean, we're obviously we're going to do whatever you tell us to do, but we're looking for some guides as to if there's anything we can get you prior to that evidentiary hearing concerning those memorandum interviewed by the SWED agents and the videotapes. Whatever you instruct us to do. Thank you for some help. But Your Honor, we mentioned, and Mr. Griffin reiterated to me just now, and obviously you don't need to tell us this today because we're not going to be doing the questioning, but there is the consideration of 606B and the incursion into deliberations. At some point, we don't need to know that today, but at some point prior to you questioning the jurors, we'd like you to enunciate what your position is on that.
You're going to have to outline that a little bit more for me. What part of 606B are you discussing?
Well, it says, if I can find my glasses. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind as or emotions as influence a juror to assent to or dissent from the verdict.
All right, so and what are you saying that imports for this procedure?
Well, I mean, for instance, if we show you, we prove to you that the court said, do not be fooled, or, you know, watch Murdaugh's testimony, watch the body language, inferring he was lying, he would be lying. One of the issues is if the juror who sat during the deliberations and said that the court said that, did she discuss that with any other jurors? Did she infect the jury? Does this allow you to do that?
Well, you certainly, if you go to 606B, it gives you some guidance about that. It says, an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotions influencing the juror to assent or dissent from the verdict or indictment or concerning the juror's mental processes, except a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention, or whether any outside influence was improperly brought to bear upon any juror, nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which juror would be precluded from testifying be received for these purposes. I take that to give us the guidance we need about the parameters of the questions.
But if, again, if the juror that gave us the affidavit, would she be asked, did you discuss that during deliberations? Can she do that?
That apparently is very questionable under the terms of 606.
Yes, ma'am.
And I intend to abide by that. The way those questions have been asked in many cases I have reviewed is to ask the juror whether that's still their verdict. If they asked about improper context and they talk about improper context, then the way to pursue it beyond that for the judge is to ask about the impact on the verdict, not on the deliberations themselves. That may be a small slice of difference, but I think it's very important to understand that no one, not myself or anyone else, is going to be asking the juror about the specifics of their deliberation, and the rule is quite clear about that.
Okay. And is it clear that you will not be using the SLED interviews or MOIs to attempt to impeach?
I told you when that was brought to my attention in our Chamber's conference this morning, I haven't made my mind up about that. I don't know what's in those summaries or anything else, and we don't have to discuss that. But again, I'm the one doing the questioning at this point, Mr. Harper.
Yes. Yes.
And I'm trying to see what you all are asking, and I'm gonna go to the state now and see what their reaction is to what you said.
Thank you, Your Honor.
Mr. Waters?
Thank you, Your Honor. May it please the court. Your Honor, again, we would concur with what Your Honor just said about Rule 606 and, of course, all the cases that we've talked about and the need to show prejudice. And obviously, when you're talking about external influence, that prejudice, which will be an appropriate subject of inquiry to the jurors, is whether or not there was an impact on the verdict. And we, of course, have suggested to Your Honor, not only based on the cases, that should be judicially conducted in a manner that protects the privacy of those jurors and it protects the privacy of their identities. These jurors, were drafted into service, and this inquiry, of course, has to happen, but it needs to be conducted in a manner that respects their privacy and should be, of course, judicially conducted. We have suggested those two questions. If we look at the Bryant case specifically talked about the fact that depending on how the examination goes, there could be questions suggested by the parties. And obviously, I think we would need to cross that bridge if and when that bridge needs to be crossed. And that starts with the court's inquiry to those jurors, and only if something arises that needs further inquiry could that be addressed at that point. And that could be even a discussion from counsel with the court as to what additional questions may be proper. When the state first became aware of these allegations, the first thing that we did was have SLED do an independent investigation, and the goal was good, bad, or ugly to get to the bottom of what, if anything, happened. And the result of that is why we're still here today. And that is that in speaking with the jurors that spoke to us, that the balance of the evidence, as well as in talking to the clerk staff, was that there was no impact on any verdict. There was nothing unprofessional or untoward that happened that had any effect on the verdict. And so when we did that inquiry, and that is what the jurors said, that is why we're here today, and that's what this hearing is going to address. The only juror that we have is the one who
Okay, their feed is spinning on me, if you can hear me. Mm.
filed the affidavit. That's 6:30, and even she, or that person, only said that she, eventually voted guilty because she felt pressured by the other jurors. Did not even mention any external impact. And so, unless she's going to change her story,
You can hear me, okay.
Her affidavit. So, the balance of the evidence is the reason why we're here today, and while this hearing needs to take place. Your Honor, as far as inquiry to those jurors, again, there could be a need that the parties would suggest questions, and it could be, depending on how things go, that the affidavits or maybe even the recordings, all of which have been provided to the defense, the full recordings of those interviews of any potential witness in this case have been provided to the defense. It could be that issues could arise from either the state or the defense as to impeachment, and we can address those issues as they arise under the appropriate rules, 608, 613, and the like, dealing with not only prior inconsistent statements, but other evidence that would be properly impeachable. Ultimately, I do need to address one thing as it deals with all of this, and that is the defense's contention that somehow the clerk is a party opponent in this particular case, and we believe that that is incorrect. Obviously, there is a hearsay exception or a non-hearsay determination in the evidentiary rules, I believe in 801, that excludes statements of a party opponent. But just because the clerk is an elected official and of the state, that does not make them a party opponent in the way that term is defined. A party opponent is an active litigant before the case, and that is, I think, different. So we would certainly say that the hearsay rules would still be in effect as it relates to Ms. Hill and any testimony that she may provide. I know there's been some discussion about the order in which the witnesses may be called and whether or not Ms. Hill would be a hostile witness. And obviously that's under Rule 611 and I believe C, which will allow leading questions, if a person is hostile. I think, again, at this point, I don't know that any showing necessarily has been made, but I understand the defense may raise that point and we may have some arguments at that time. But I don't know that there's been such an identification between Ms. Hill and the state that would allow her to be identified as a party. I think that's far out of bounds, but also that she would be applicable to allow defense leading questions under 611C. Your Honor, in looking at the type of examination that would need to happen here, and again, the issue also arose of the Fifth Amendment. And I know that the defense would like to brief that issue, and we're happy to respond. We don't know exactly how that might arise in the course of any examination. We need to cross that bridge again when we get there. We would say, though, that the Fifth Amendment is question specific. And so, again, it may be something that this court has to rule, as in any sort of evidentiary presentation, question by question, based on any objection by the party. So it's kind of hard to say that exactly what a blanket position would be until we actually get to that determination. Ultimately, the defense referred to some information provided this morning. Actually, both sides exchanged last night their communications with the clerk during the course of the trial. So both sides did that last night. And there were a lot of communications with the defense as well. And so, again, I just want to point that out that there's any sort of allegation or insinuation that the state's not providing information. We've been very diligent about providing any and all information to the defense. And if any additional information arises, we will continue to do so. But both sides exchanged that last night. And of course, there's been some reference in their filings as to emails that were forwarded from the clerk to me and to my paralegal, and they've actually even listed me on the witness list. And Your Honor, as we have had a chance to peruse the defense communications with the clerk, there was just as much communication and offers of help. It was just a uniform across the board courteousness that's reflected from those. So we think that that's a non-issue, and we think that should not be something that arises during the course of this evidentiary hearing, at least as it was required communication from or testimony from attorneys. Your Honor, ultimately, as we look at the inquiry that will need to be conducted, as the state has made clear, it starts with the jurors. And only if something arises in that inquiry, further inquiry to those jurors may be necessary. And that could be in discussion with the parties, as I've stated before. And then I know Your Honor has indicated the clerk should testify, and we certainly understand that. The clerk filed an affidavit denying any of these allegations. And so, again, as we address the clerk's testimony, the state would have objection to some of the information I believe the defense would propose to examine her on. We believe that an inquiry should be limited to what is appropriate and relevant impeachment, but not should be just a far-ranging fishing expedition or full inquiry into a lot of subjects that have come up since the trial that we believe are not relevant to any inquiry that is before the court here now. Obviously, rules 404, 401, 402, and 403, as well as, which of course address relevance, and 403 objections, 404, which addresses other crimes or wrongs or acts, Rule 606, 608, which addresses inquiry into other specific acts and impeachment, and Rule 613, which talks about prior inconsistent statements. All of those rules potentially could come into play depending on the nature of the testimony and the nature of the inquiry. But there have been allegations since the trial about the book, about this wiretapping case, about investigations into alleged use of office for improper gain. But again, all those are subsequent to the trial. And so again, depending on how the testimony goes, the state would raise appropriate objections at that time to limit the inquiry to what is appropriate for what is before the court we would submit. And that is what occurred during the trial. So we would make those particular evidentiary objections as things developed. Ultimately, that would be the state's position. I know that we're trying to put as much meat on the bones as we can at this particular point in time. But I think the reality is that the court's inquiry to the jurors will really determine the nature of the inquiry that needs to proceed from there. And at that point, the state would take the positions that I've outlined here today.
You reply.
Please, Court, Your Honor. 404, I find it somewhat ironic. The state is quoting Rule 404, Your Honor. One of the exceptions to 404, I noticed would be surprising to Mr. Waters, is motive. As if he's never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book. Motive, selling books. So we believe we should be able to get into that. We should be able to ask Ms. Hill about it. If she denied it, to call that witness, that assistant, and have her testify that she was told that. I mean, why would a clerk do what we allege she did? We think is important for Your Honor in terms of credibility and context. That's number one. Number two, Your Honor, I think we've all agreed, you're going to ask the questions, whether we agree or not. And we do agree with that. The question is going to become, as we go through that process, how, if a juror says X and they've said in their interview Y, or if they've said to us Y, or didn't include it in their original affidavit, and you don't ask that question initially, how are you going to handle, or do you care, how we suggest to you a further question? Because as Your Honor's seen this morning, the back and forth can go on for a while, and we certainly don't want that to go on with a juror. So we're going to need some guidance on that. I'm not expecting that guidance this morning. The last thing is, as these jurors are examined, I need to understand a little bit about the logistics. Are we going to do it in this courtroom? Are we going to do it in another courtroom? Is the public going to be able to hear the responses? Will there be an audio feed if we do it somewhere else? Are you going to have cameras turned, you can do it in this courtroom, have cameras turned off? And we're obviously not going to refer to jurors by their names. Even though 3 of these jurors were on the Today Show, another one went on ABC. They were all in the courtroom when the judge had them brought in. They were in the courtroom, all except one of them for the verdict. Cameras were there then. Again, I'm sensitive to their anonymity, but I don't know that any of them have any real anonymity anymore. Saying that, I think it's important not only for Your Honor to hear their answers, but for the public to hear their answers. Thank you. Thank you.
All right. With respect to the jurors first as witnesses, I will be doing the questioning of the jurors, and I will notify the parties pretty promptly what I intend to ask the jurors. The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked of jurors on 2 levels. One, as a predicate to what you want to do with the clerk herself in examining her. And 2, as a means of further attacking the credibility of the clerk in her testimony. I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth. I will be open to receiving that if it's done promptly, because we've got a hearing coming up the 29th, and I want there to be plenty of time to revise any current ideas about who to subpoena, who to call as witnesses, and who has to do that. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her or characteristics of personality or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury. So I am very mindful of the limited nature of it. As I say, I'm not excluding submission in advance of information that would take the questions beyond the limited questions I've initially indicated. But I will be very hesitant about any of those questions as it involves propounding those questions to the jury. As it involves questions to Ms. Hill similarly, this is not a time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am the judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary, nor do I think it's proper, to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be used. I can't imagine allowing thousands of emails to be made exhibits in this process. Either emails sent by her to attorneys in the case, to other court officials in the case, or to other individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical dealings with the county, and so forth. This is a very focused inquiry about this jury and its ability to render the verdict it rendered in an impartial manner. So I say that to tell you that when the clerk is offered, and I think the clerk is going to have to be offered as a witness, the whole allegation revolves around the contention that the clerk made contact with the jury about matters material to their verdict, that contact was improper, and that it impacted their verdict. There's a whole lot more that Mr. Harpootlian has indicated he'd like to explore that I regard as totally extraneous to the inquiry that we maintain. I'm not going to allow those questions to be asked by way of proffer and then have the clerk answer those questions and have that be the proffer, although I consider them irrelevant questions. We're not going to handle the case in that way. If I exclude a certain question from being asked, then the proffer will be whatever in writing is chosen to be offered in that regard. But I will not conduct a hearing where there's a whole side hearing in which every question desired is asked and either required to be answered or dealt with in some other way. I don't think that is an appropriate use of this very targeted hearing that I'm directed to have. I also think it makes a great deal of difference whether the questions that are being asked relate to the clerk's conduct at the time this case was tried, as opposed to other conduct at a later time or in connections with other things than the trial of this case. So I will be looking very carefully before we conduct this hearing and trying to give the parties as much advice as I can about what I would find to be acceptable topics to pursue. I think you're entitled to that, but I also think the record of the case is not to be used as a platform to explore each and every fault of each and every witness, whether it be the juror or the clerk. And I'm not going to have the hearing conducted in that manner. I think there are other ways of preserving topics that I rule should not be pursued than having those questions asked and answered, even though I ruled that they're not proper in the hearing. So I hope that explains kind of where I am on the subject of how questions are asked. And therefore, some of the suggestions that are made in the filings you've made with me about the additional witnesses you'd like to call and subpoenas, I think we need to be sure we're all on the same page about what is acceptable in evidence and what is not. But I can tell you that I would not allow the subpoenaing and examination of attorneys in this case, of the judge who heard the case, or any of those type of witnesses. This case is very focused on the jurors and the clerk of court, as I see it. Now, it's about 11:15, close to it. I'm going to do this. I'm going to take a break for a minute. Let's take until 11:25 as a break. And in that time, I would hope that you formulate the other things you think we need to look at by way of the specifics of how this matter is to be conducted. I will then do two things. When I come back and ask you for further ideas, both sides, as to who should be called, get very specific about who can be called and who cannot, who should offer these witnesses. And I would also at that time ask those who represent potential witnesses in this matter to come forward and have a conversation with me about your position on behalf of your clients. I think that's particularly important because as we have the actual hearing itself, I've never heard of a situation where a witness can have their lawyer actively participate in the examination of the witness in a proceeding in which the witness is being offered. So I would not allow that, but I think we can protect the legal positions that attorneys for witnesses want to take and need to take and want to put on the record by pursuing in the way I just outlined, and I'll be prepared to do that when we return. All right, court will be in recess.
Thank you, John. Thank you, Your Honor.
Okay. Okay. Oh, for 30 minutes. Okay, so I think what I will do is mute that. Okay, it's like we can keep an eye on what they're actually doing. They're going to put him back in handcuffs and take him over. He can still confer with his attorneys, of course, off to the side. They have to take him out off to the side. But his mood sure did change with the judge. Yeah. I think she said quarter up. That would be 30 minutes, and I thought she said 30 minutes, but I'm not sure. I hope. But we'll keep an eye. I'm gonna bring this down and just put myself up once they move him from the room and we see, because this is the feed. There's gonna be commentary on Fitz News channel. There's several other news channels that are actually doing this, and also I believe Law and Crime. And they'll have, of course, there's going to be plenty of lawyers. I believe Emily Baker is also covering it. But I'm going to leave that down there. Unfortunately, the channel 19 feed did not actually work very well. No sound at all I was getting on that. I do not know what happened with that one. I've had problem before with that. But there was also a press conference from the district attorney Ray Tierney in the Rex Harriman case, and we're going to be talking about that later tonight. But he has been charged with a fourth murder, and we'll go over everything. There's so much to go over today, not just this actual hearing we have here, which I want to get. I'm going to still record the rest as we go. No, Tsunami, the judge spoke. She's coming back in 30 minutes. She's asked them to confer about evidence so that she could go over, but she did, just to give a quick synopsis, Tsunami, that you came in. Basically, Judge Toal, very strong, very knows her law. She's got a hell of a reputation. I've been reading about it for the last couple of days. knows her law upwards, frontwards. She actually like took apart like both of their little bits in both of their arguments as to the cases that they brought up and said, nope, this one doesn't pertain. Nope, that one doesn't pertain. And she's basically drilled it down to, I will be the one asking the questions to the jury. I'm going to do it off camera myself. It is important what they tell me. Like it's my decision. It's not what you guys tell me. It's what they tell me in how I go forward. And she's got it in home. So she's drilling it down to the issue, not Becky Hill's reputation, not anything else they're finding out about how horrible Becky Hill might be, about this, that, and the other thing, but whether or not the jury was influenced and whether or not Alex Murdaugh got a fair trial, period. And whether or not he needs a new trial to protect his rights. Okay, it doesn't have to do with whether Becky Hill made money, whether Becky Hill is up on charges for other things. I mean, that of course doesn't look good, but she really shot Harpo down in regards to bringing everything else into it. 3 channels streaming in your feed. Hey, which one besides Law and Crime? Like, are there any regular news ones, Naomi, that I can actually try to pull up? Because the Channel 19 one had no sound, but Fitz News did, you know. But I could not find another one that had sound. I mean, Court TV, of course, and Law and Crime, of course, they have their feeds. Oh, and Luna. Okay, yes, yeah, Luna, and you know, there's a couple of other smaller channels too, and they were using, like I saw some of them were going to start to use Channel 19, and I don't know if it was like why we weren't able to actually get that news feed up like with sound, you know. Who's Tasha? I don't know. Well, we're going to see if there's like, you know, audio on the on Channel 19 again. Okay, it looks like they may have fixed the audio. I'm going to try the other stream when they come back. There. So, let's just see what everybody's talking about in the chat. Welcome back, Couch. Tasha is yes, Tasha is with Fitz News. Yes, I know. And Will. Yeah, Tasha, yeah. And okay. Yeah, Rocky Couch. What you missed was the judge actually laying down that she wants to keep this to actually was the jury influenced or not, and she'll be the one questioning the jury, and she's asking, you know, the defense in the state to come forward with questions, but to keep in mind that they need to stick to the issue. They don't want to hear all this stuff about Becky Hill after the fact, this, that, reputation, whatever she did wrong here, there, the other. She's not turning it into a circus, basically. She says stick to the issue. In so many words. Would you guys agree that that's a good synopsis? Judge Toal said, stick to the issue, give me your questions. And then she also reminded them, and I will decide whether those are the questions going forward. I think she said that several times. She clearly took control of that courtroom and reminded them, it is all up to her. she gets to decide what they get to ask, what witnesses are coming up. Like, you're gonna have to prove that it's part of it, and not just a fishing expedition for how you're going to present your case, which is kind of sort of the lecture she, in so many words, gave Harpoolian after he spoke about Becky Hill's motive of making money off a book. Well, we could say the same thing about Jim Griffin's making money off the podcast while the trial was going on, like making podcast deals. Yeah, or Harpoolian. We could say, hey, with your actual political aspirations in running for office and all of that, like, well, there's motive there too. For a mic, really hot contrary case to keep you guys in the news. But hey, the judge isn't hearing it either way. Hey, Godless, how are you? Hey, Jeff. Oh, I have to apologize. I sound terrible. I don't even know if you can understand a word I'm saying, because like the echo in my own head is horrible of my voice. Tsunami, I get it. Yeah, no heart pulling around. Exactly. Yeah, not this time. We'll save the clown show in the circus. Leave the circus in the field, not in the courtroom. There you go. Yeah. Yeah, Carrie Ann, that's exactly what they wanted to do. They want to rip apart everything. They want another crack at SLED. They wanted a crack. She also, Rocket Couch, something else to make note in everybody in chat, and I definitely did, was that she said, you're not going to be questioning the attorneys in this case, nor the judge. How's that? So they did put Crichton Waters in Judge Newman on that list. And she just basically took them off. She said, you're not subpoenaing them. If they want to come in to give willing testimony, that's one thing. You're not going to be able to subpoena people this way, because that's not what it's about. It's about whether the jury was influenced. And the only one who knows if the jury was influenced, because here's the thing, prove, okay, that the jury was influenced. The only one who could prove it is the jury. Yeah? Because you don't get to speculate on what they were thinking. You don't get to decide for them what they were thinking and what mattered. They know she's going to ask them directly. So basically, the three-ring circus is being shut down pretty much. There's going to be no like displaying all of these like media experts that'll come and say, if you say this word, this is what this person thinks. And, if they're exposed to this, they could, with a 72% chance, like make a decision based on blah, blah, blah. No, it's not going to be like that at all. I don't know what they were hoping, but they didn't look as hopeful as it went on. Yeah, they must be Liam. Yes, that's right. Like, let me just pull that up. Like, I tend to agree with you here. What are we going to do about them? Because we know that SLED has never offered free rides downhill for children in the snow, so they must be biased. Exactly. Let's put them on trial. But let's just say that the Murdaugh defense team has been very cross and very attacking of the whole investigation, SLED in general, all the attorneys involved, everybody. They have been really like very attacking and very like very not nice things that they say and accuse them of. Like apparently, we all know that the Murdaughs had some great connections in that area, but apparently when it came to Alex Murdaugh and the things that he did, a lot of those connections, they just couldn't count on them anymore. And a lot of people are pissed off. I mean, there's sides on everything there. And there seems to be, in South Carolina, right there in general, in that whole county, there seems to be a lot of corruption being exposed on all over the place. So Judge Newman, when he made his statement about Alex Murdaugh and Doug, Harpoolian and Jim Griffin throwing their whole judge, their whole system, into a shady light with all of this is kind of true, because if there's nothing to it, like what they've done is just made it like so bad. Alex Murdaugh has made it that lawyers in general in the area can't be trusted. All the people that he involved in his like shenanigans, he's already, even if he gets a retrial, okay, he's not going to get out of jail. He's just not, he's going to go through the whole thing. And that could be legally fascinating because we don't know if the 404, if the 403B information of financial crimes are going to come in. And now that he's confessed to them, I think they are allowed to actually bring it in. They could be. It will be prejudicial to his actual reputation. So maybe not. It's definitely prejudicial. But remember, they brought it through his motive. And so it would still be motive. But a different judge may feel differently than Judge Newman. So we'll have to see. But they still have the video. We'll see, because we don't know what evidence they're going to be able to put in. Yeah. I hear you. I hear you. Let me just see. Okay, I'm going to try to bring up another feed. I'm going to switch feeds temporarily. Okay. Just that they're giving a little bit of let me just make it bigger. Yeah, bring it up. Okay. Just so you could see that's attorney the balding dark-haired man on the far side. That's A.G. Wilson. He's next to Creighton Waters. I do not know who they're talking to. I have to remember the gentleman Brian in the back. He's standing near some of the younger prosecutors, but he was the lead prosecutor actually behind the scenes with a lot of the evidence that was coming in and documentation of the financial crimes. He worked tirelessly, and he actually worked with John James, who was a younger DA, assistant DA. He was the dark-haired young man with the glasses who did a lot of the presentation for the financial crimes there. Worked with him day in and day out. I have a lot of respect for that team, the way they all work together, Just the law clerk with the defense. They do not look as animated. Make sure the volume's all the way up when it comes back. It's funny, different channels are showing different views. Some are staying on the prosecution, some are staying on the defense. It's interesting to know what they're looking at. There is not. I'm going to look and see if we've got questions. Jim looks like he's aged just over the list. He does look a bit tired. I mean, he was looking pretty tired at the end of the trial. I'd say he looks very similar to when I last saw him. Yeah. Oh, it's like, I mean, he's got all of his political stuff he does too. Remember, he kept getting everything delayed in the Murdaugh trial for his Senate or whatever the stuff. This he's a senator, whatever he had to take care of. Um, in some other like big case that they had to cover. Mm. All right, I'll bring it back down. That is a little bit boring, so I'll bring that one back down. Okay, and we'll just keep keep an eye out for when they come back. Well, no, Harpoon looks like he's been looking through chicken. Oh yeah, not really. It hasn't really changed much. Oh, you said Jim, Tsunami. I thought you mean Harpoon. Like, yeah, Jim does look a little bit worse for wear. He has lost some weight. He looks a bit haggard. He looks very tired. I know he's got a lot like going on. He's got this new podcast. He does some YouTube now. He's been doing the circuit. I think he's actually picked up a couple of other cases too. But he also does a lot of the legal brief writing. So I imagine he's been pretty busy. This this judge is definitely going to keep to a timeline. You saw she kept referring to when that hearing would be for evidentiary. So these questions, this stuff, she wants to get stuff knocked out today in regards to what's going to happen at the end of the month. And I do believe that we're going to be able to live stream that also, depending on the allowance of the feeds. They're limiting everything to only a certain amount. Law and Crime was it, or Court TV in charge of the actual pool, and then there's a whole bunch of others who asked, like, to be able to stream it and stuff like that. So usually the news organizations and all that are streaming it, we did not have trouble last time during the Murdaugh trial, but we shall see um how it goes. As long if they keep it up for us, that would be great. I will be crediting all of the streams that I use down below. We'll see. But Harpo puts on a show for the courtroom. He's a hell of a. He is actually a very good defense attorney. He's got a stellar reputation, actually. I mean, he's been around for a really long time. Yeah, but he's also likes to toss a lot of dirt. Like he likes to muddy up, you know. So there's that. There is that. I think Liam says, I think they knew that ploy was a Hail Mary and already prepared with a reasonable set of requests. I think they do know that the questions they need to harp on, like they know what they brought forward, at least. Okay. I'm going to bring it back up because they are bringing him back in to the room. So, which means, we've got 10 minutes until she said she'd be back. So they're getting him ready. I'm hoping to stream tonight at around 7 p.m., possibly 8 p.m. Eastern Standard. Hopefully, I'll be able to do it at 7 p.m. because there is so much to cover. Oh. Okay, my turn. I've got to have another cuppa. Seriously, I've just finished one. This was last minute, also. Okay. Why again do I not have any sound? Okay. Okay. Do you guys hear anything? Okay, I have to switch feeds again because again the sound is not coming through on that one. Damn it. Ah, I thought for sure it was going to be okay. Well, thank you, Fitz News. I appreciate it again that you guys got sound.
Everything will be done in open court. The jurors will be referred to by number. The court TV cameras, which are the ones used to film these proceedings, will not be allowed to focus on the image of the jurors as witnesses. And if there's some need to further obscure the way they are presented, we can talk about that. But they'll be examined right here in the courtroom as other witnesses would be. And I kind of looked at a little bit of exchange we'll have with attorneys for jurors to see what we can work out about exactly how the jurors are presented. But everything will be on the record here in open court with measures taken to ensure the privacy of the jurors. No photographs would be permitted of the jurors or anything of that nature. And I believe if I announce that in advance, the press that are present, the press that have covered this proceeding throughout have been respectful of the judge's requests, and I'm very confident they will be in this matter as well. With respect to the alternate jurors, I will question only the jurors who sat and considered this case. So the alternate who was dismissed by the trial judge. That alternate did not participate in any way in the deliberations about this case. There's nothing that's been brought to my attention about anything the alternate might have done that was improper at all in terms of communications with fellow jurors. Nothing's been alleged in that regard. So our focus will be on the jurors that heard this case and not on either that alternate or any other alternate juror that has been proposed for questioning. I will not permit that. With witnesses or testimony, I do not allow. Let me explain about proffer. Proffer will be a written proffer by the party dissatisfied with the limitations of my ruling. But there will not be some examination as to proffer. The proffer will be a written proffer by the attorneys in accordance with their positions about witnesses and testimony. With regard to the subpoenaing of witnesses, the parties should subpoena these witnesses. And when it comes to the jurors, I would urge that the parties, the state and defendant, jointly deal with the issue of subpoena of these witnesses. I do not think it is the court's place to subpoena witnesses or order witnesses' appearances. This case is driven by the parties and their positions. The initial position of defense was that only certain jurors should be called. The state said no jurors should be called, but if you do, all should be called. All who sat on the case should be called. Measures in that regard. The concept I would have is that the jurors would report to a place that I will specify, and when they report, they would be taken to a room with appropriate supervision by court personnel, and then called individually to recite their testimony. And then when their testimony was complete, they would simply take their place in the jury box until all were questioned. And then if there were any questions further by me that would be collectively made to the jury, I could do that. And if there are any further questions that were submitted to me by the parties that I chose to question, I would do that. And then when all of that was complete, the jurors would be allowed to be dismissed. So that is how I would handle the juror witness portion of this. And of course, I know I'm going to get some commentary from each side about that, but that's why I talk about this in advance. The other witness that surely needs to be called because of the allegations made is the clerk of court. The state has submitted a preliminary affidavit by the clerk of court, and the defense has many areas that they want to explore for the court. Again, I would like for the parties to develop some joint way of subpoenaing the clerk of court. And if I need to be a part of that, then I'm sure the parties will let me know. But I say this for the benefit, particularly of the attorney for the clerk of court, to know that I would expect that the clerk of court will be called as a witness in these proceedings, 29, 30, and 31 if necessary. We'll be using the same courtroom for these proceedings, this courtroom. But we'll see. We'll have this. I will try to figure out a way to ensure that the broadcast in here of the proceedings will not interfere with the conduct of the hearing past this partition next door. I will trust Mr. Bender to work with the press to arrange the courtroom and the overflow room in accordance with the rules I will set forth here and anything else that may come up that needs my attention. I think that covers it at the present time. So the first thing I'd like to do is to get some clarity from the attorneys as to what furthermore, for the parties, as to what furthermore needs to be discussed. And then after that, we'll explore with the attorneys for the jurors and the attorney for Clark Hill, any other issues that still need to be developed. Mr. Hopkins.
Please support, Your Honor. I'm trying to make sure I understand what you just ruled. Are you ruling that we cannot call the alternate juror or the so-called egg lady to corroborate what was said to the sitting juror, since they were all told this at the same time?
I'm not sure I understand your question, but I'm telling you that I want these jurors, these alternates would be called apparently to testify as to what the clerk said.
Yes.
At the present time, I see no necessity for them to be called to say what the clerk said, because we're talking about what the clerk said to the remaining jurors, those who actually sat on the case. The corroboration is something I don't think I need at this time. I think I'm perfectly capable of evaluating what the jurors tell me, and I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors for that matter.
Well, Your Honor, for us too, and then you said you wouldn't allow a proffer of that except in writing. Now,
yes, I'm not going to have a courtroom proffer of any kind. If you want to proffer what would be offered by means of affidavits, copies of emails, anything else you want to, that's fine. But I am not going to have a courtroom proffer, no. I think the only reason for the proffer would be to preserve your right to appeal. I believe your right to appeal my rulings will be perfectly preserved, frankly, even if you didn't have a proffer. But even more so if you supply an in writing proffer.
Well, I'm trying to determine whether an affidavit is sufficient for an appellate court, federal or state, when the state won't have an opportunity to examine that witness. But I mean, they've given, I mean, we can get more detailed affidavits. You know, these people are witnesses to what the clerk said to the juror who deliberated. I don't understand how that can't be relevant to Your Honor's decision. I understand there's two steps. One, did she make the statement? And two, was it prejudicial? These witnesses corroborate she made the statement.
Well, of course, that's what you say. So far, I haven't seen any of that. If that's what you say and you offer it to me in some form that I can evaluate it, I may revisit that decision. At the present time, but at the present time, I see nothing that prompts me to think I need to have people who did not sit on the case talk about what they think the clerk said to other people, when I've got to direct people to whom it said that I will question.
Well, Your Honor, we did submit an affidavit, but I have no problem with going back.
You submitted one alternate affidavit,
Right.
and one affidavit of a dismissed alternate. I'm aware of that.
Right. So.
And that doesn't prompt me to change what I've just said to you.
All right, we can get you a more specific. I understand what the questions are you have, and I would only put those folks up to deal with those very limited issues that you described. Put them up in 10 minutes.
Well, again, I'm not going to rule in a vacuum. I'll see what you say, and I'll rule upon it.
We'll get affidavits and file them with the court.
Very good.
Thank you.
Your Honor, just one issue as to logistics. Obviously, these jurors are down in Colleton County, and we're up here in Richland County. I've spoken with SLED, and in as much as we need, there may be jurors who need transport. SLED has certainly agreed to have 12 cars if we need to make sure that they're individual. They can then come in through the garage, and obviously they'll be brought up to a jury room. I think Your Honor indicated they can be in a jury room with a bailiff in there to make sure that no one's talking about their testimony and that sort of thing, but also so that they don't have to come in through the public entrance and that sort of thing. So that would be.
I think that would be a good solution, and of course, to satisfy the concerns that the defense may have, you could either have a member of the defense team or one of their employees ride with them, or if you could agree upon a sworn statement by the agent or person that does drive them, that they, A, will not say anything, and B, did not say anything, then that may cure the problem too. I think you all can work that out. But I do think having proper transport would, first of all, be a comfort to the witnesses themselves, the jurors themselves. But if they can arrange something otherwise, of course, they'd be free to do that. But to the extent it's a burden on them, yes, I think that's a good idea. And in all events, I would want arrangements to be made to have the jurors come to the parking garage in this building and be escorted up in a private way into their assembly room.
And yeah, absolutely, Your Honor, and we will, and I'm sure SLED, I've already spoken to them about that, have uninvolved agents who will be under strict instructions not to discuss the case, and happy to have them sign affidavits or whatever.
Very good. All right, anything further before I go to the lawyers for the jurors? All right.
Your Honor, only one other point, and that is you asked us to give you exhibits that we would use.
Yes, sir.
Having not asked or had the opportunity to ask Ms. Hill a single question, I can't tell you in terms of, there's not thousands of emails we've used, probably 5.
I'm just going on some of the descriptions that were in the filings y'all have made to me.
Well, we've received thousands of emails from Colleton County based on a subpoena we issued. We've received hundreds of pages from the AG's office and from SLED. We are.
It'll make it a lot simpler if it's a small number and a discrete number, submitting them to me. Again, I told you I would evaluate that when I did.
Of course, I don't think you can evaluate them until she testifies. You know,
I think you're gonna have to trust that I am gonna do some evaluating before she testifies.
Okay, and Your Honor, you know, she's given an affidavit denying making any of these statements.
She has.
So these alternate jurors that have been dismissed, would you allow us to call them to impeach her if that's what she testifies to?
At the present time, the answer to that is no, as I have indicated. But again, I'm not gonna rule in a vacuum. I would hope that what you all will do is send me a pretty specific idea of what you want and how you want me to permit it. So I'm not gonna rule on something I haven't seen yet, which is your proposal as to exactly how these witnesses and alternates to be used.
All right, we'll get more extensive affidavits from those two alternates.
Oh, okay.
That's
fine, or descriptors of some sort from you as to what you intend to do. I'm not gonna dictate how you do it, but I'm gonna have a lot more than just kind of the generalities that have been discussed in these briefs in order to permit.
Well, I think we're gonna need an affidavit for appellate purposes, nothing else. I mean, my description to you is not evidence.
Oh, I agree, but you know, again, I will tell you how I'm gonna accept the proffer. What you put in the proffer, in the written proffer, is up to you. I don't want to dictate that or manage it.
Well, I just want to say that we're going to hopefully be able to get affidavits from these folks.
Yes.
Much more descriptive than the original affidavits.
Oh.
Thank you.
Oh.
Your Honor, may I consult with counsel very briefly?
Certainly.
He seems very concerned about that one alternate affidavit, which supported what the egg lady said. And neither of them are able
One
to
of the things that
testify
was
right now.
discussed earlier was the independent SLED investigation that was done. There were recordings of some of these interviews and MOIs prepared that were just meant to be summaries. I know Your Honor mentioned earlier that you would be open to receiving those.
Sure, I'd be glad to review any of that.
Discussed that with counsel, and I believe they said, well, we want to send the ones we want to send. I think if Your Honor's amenable to that, we would just add Your Honor to the discovery upload that was provided to the defense so that information is available to the court for whatever purposes the court deems necessary.
Can I ask this?
Yes, ma'am.
First, would that discovery upload include your interviews, the tape of the interviews, as well as your summary of them?
Yes, ma'am.
All right. I will ask you to let my clerk, Eva Diaz, talk with you afterwards about how to send me something of that volume.
Sure.
Our court, IT has a lot of barriers in our system to us receiving even conventional websites and web tools for examining in volume documents. And so I will want her to interact with you all about exactly how I am to receive that material. But yes, I would be happy to receive it.
And we would be happy to get a couple of flash drives and provide it that way, if that makes any sense.
That might be the better way to do it, because, again, I can very easily examine a flash drive, even though it takes a long time, particularly if you are kind enough to provide an index at the front of the flash drive as to where the various materials are located. That might be better than using one of these web document sources, since so many of them are excluded from our system.
All right. Well, we'll prepare one and have a copy for you, Your Honor, and then for Ms. Diaz in front as well. Thank you.
Now, on my list, I have in the courtroom at this time, Mr. Bland, who represents certain of the jurors, Mr. McCullough, who represents certain of the jurors, and Mr. Lewis, who represents Ms. Hill. Are there others in the courtroom who represent jurors or Ms. Hill?
But Your Honor, Ronnie Richter on the Earth Claims Department.
Went a little fast for me.
Ronnie Richter.
Oh.
Mr. Blank's partner.
Right. Any others? All right. Well, then we'll begin with you, Mr. Bland, if you and Mr. Richter would come forward.
May it please the court, Your Honor. Ronnie and I represent 4 jurors who rendered verdicts in this case.
I would like their numbers, but only if that doesn't violate the attorney-client privilege. You may give them to me now or later.
Can I give them to you later? I have them now. Our job is we want to preserve their anonymity.
I understand.
2, we want to make sure that they're not harassed. And 3, we want to make sure that the verdicts of their conscience remain. And that is not only because they voted guilty. If they voted not guilty, we would feel the same way. After hearing what Your Honor has established by the way of procedures, we're very comfortable with what you have established to protect their anonymity and that they're not harassed. Ronnie came up with a good suggestion. Maybe you renumber the jurors 1 through 12. And that way, because there has been some public disclosure of the jurors' numbers in some of those emails, they were the big batch of emails that Mr. Hartman referenced. So maybe we cross-reference with the chart 1 through 12 and the juror numbers. But as far as the questioning goes, there's no need for us to be part of this. You're going to make the questions. You've indicated that you're going to preserve their anonymity, that they can't be photographed, they can't be on videotape, and that's about all we have to add.
Yeah, Your Honor, I would amplify that I certainly respect and appreciate the significance of the issues that are before you. And I respect your decision that you're going to make this public. I would have asked you to make the jury portion a closed courtroom. And Your Honor, only for this reason, that I don't know what the jurors are going to say, I don't know what you're going to rule, but let's just say in a hypothetical setting that because juror number 9 said something that you believe deprived Mr. Murdaugh of his right to a fair trial, you're going to grant a fair trial, a new trial. I would hate for there to be any mechanism for somebody to backtrace to who was juror number 9. Because I know the public has very firm opinions about this matter, and I wouldn't want that person to be subject to any kind of public scrutiny. So I would have asked of you that for the juror portion, that would be closed courtroom, that the press would be present, that their likeness, both voice and face, be muddled, just as an additional safeguard. But I certainly appreciate what the safeguards you have put in place. I respect your rulings. I just throw that out for consideration. And on a broader perspective, I know that you've had this experience as well, Your Honor. It's becoming more and more difficult in this state to see the jury. And I can't think of anything more injurious to jury service on a broader perspective than to see, jurors who give up 6 weeks of their lives being pulled back in for a process like this, as necessary as it is. So I worry that the process be handled as gingerly as possible, so as not to further prejudice our ability to get juries going forward.
Thank you, sir. What I will do is this. I think your suggestion of renumbering is a good one. It's something that my clerk and I had talked about between the two of us as well. In every proceeding I've ever seen where a juror was questioned, in every case I've read where jurors were questioned because of allegations either during trial or post-trial that they had been tampered with, those proceedings have been in open court. And I don't feel it would be appropriate for me to have some kind of in-camera proceeding, even if it included the attorneys that would have to, and even if it included members of the press but not the general public. I don't think that is in keeping with the public nature of trials in this state and public nature of court proceedings. However, I think we could make some protective arrangements for when they testify and their ability to be dismissed after they testify that would protect them from being set upon to the best extent possible. So that is the way I will handle it, and I hope all things on balance, that is as protected as you think it needs to be.
We trust you, Your Honor.
All right.
Your Honor, on behalf of our clients, we will accept their service of the subpoena so that they don't have to be served.
Well, that's great, and of course, you don't represent all of them.
No, our four.
You're for, but that's great, and it may very well be that these parties are going to be able to work out something with respect to some of the rest of them. I don't know, but I appreciate that on behalf of the ones you represent.
If you want me to come up and tell you our juror numbers, you want me to wait?
No, sir. You can. I don't need that at this moment.
Okay. Thank you.
Thank you, Judge.
Yes, sir. Mr. McCullough?
Would you like me here or there?
Go to the podium if you would, please.
Your Honor, I believe that some of your rulings today, they've satisfied several of the things I was going to mention. One, Your Honor, was, of course,
How many jurors do you represent?
I'm sorry, Your Honor, I represent number 785 and 630. One is was a deliberating juror, I suppose we could call her, and the other was the removed juror.
Right. Now, with respect to the replaced juror, I think my ruling about the end of any testimony from that juror satisfies any requirements you made. I believe that I will not hear testimony from that juror, alternate juror at the present time. Now, Mr. Harpootlian is going to submit additional information. As regards your client, I'd ask you to submit that information to you as well. And then I'll see if there's any revision of the position I'll take about that. You also represent one sitting juror, so you may continue.
Your Honor, the other juror was not alternate. She was actual seated juror.
That's the sitting juror.
Who was removed at the end of the trial.
Oh,
Prior to deliberation. Whoops.
I need Mr. McCullough to speak up, please.
you need to speak up some, Mr. McCullough.
I don't get that much, Your Honor.
Yes, sir.
Your Honor, if you'll indulge me just a moment, I think much of what you've said today bears on a quote that I'm taking from the response of the state, which was filed and was part of your record. And my letter of November 10th responding to that filing is also part of the record. But the state said that jury duty is this cornerstone civic duty, needless exposure of jurors to litigative stress and impeachment by zealous attorneys in a case especially of this public exposure can only serve to discourage citizens from willingly participating in this civic duty. Your Honor, I'm delighted with your ruling that you'll be asking questions. I've been subject to your interrogative skills in my appearances before the Supreme Court. So I'm pleased with that, and I check that off the list. I would like, Your Honor, for you to take judicial notice that there have been excessive public comments by, and I have to say, Your Honor, in my letter of November 10th, I took Mr. Waters, who signed the letter, to task for labeling one of my clients, one of these jurors, as dishonest. I think I wasn't pleased with that. I think that discourages civic participation. I would ask the court to admonish the litigants, attorneys.
Mr. McCullough, let me stop you there. I am not aware of any of what you're talking about in terms of comments about the jurors or otherwise. So that's just not something I'm going to take into account by listening to it or by taking any judicial notice of it. I don't know what I would be taking judicial notice of. I do not know anything about what you're talking about.
Well, Your Honor, both my letter and the response of the state are part of the record, which you obviously have not gotten to, but I would assume yet. My only request is I would admonish lawyers, officers of the court in this courtroom and outside of this courtroom who represent people to be cautioned that this is a search for the truth, not an effort to protect the verdict, nor an effort to discourage people from participation. And negative commentary does that, or runs the risk of doing that. That's all I'm saying.
I understand, and I decline to instruct or admonish participants in this procedure in any way about what you say.
Thank you. Your Honor, next, I like Mr. Richter and Mr. Bland, appreciate your efforts. I suspect that we will decline a ride to the courthouse, but I would ask the court to consider allowing the jurors who choose not to ride with SLED agents be permitted an entry and exit from the courthouse that would involve or relieve them of the necessity of coming through the front door.
I think I've already said that I will make arrangements for juror witnesses to report to the basement where the law enforcement station is, and they'll be appropriately directed to the assembly room.
And Your Honor, lastly, I think, if I understand your rulings or discussions about the process that will occur here, this may run at odds with it, and I'm not arguing with you, Your Honor, you know best. I am of the belief that this litigative stress that I earlier referenced could be avoided, and the public and the media not denied their opportunity to gain access and knowledge of the proceedings by not exposing these jurors to a crowded gallery, a full gallery of press, by allowing its recording through, I understand, court TV will be the pull camera. That is to say that I have actually, in my history, participated in proceedings that involved the questioning of jurors, which was done in camera. So I don't think it's without any precedent, but I would obviously respect your ruling, but I would ask you to consider or reconsider that no damage would be done to the right of the public to know and participate in the proceedings, but you can accomplish the same thing by allowing the pool camera and avoid the distraction and the imposition of that on these jurors. And
I hear what you're saying, and I'm not inclined to change the ruling I've made at the present time, but I'll keep an open mind about it as we make pre-trial preparations for the hearing. At the present time, the jurors will be examined in the courtroom, as I have indicated, with appropriate identity protection.
Thank you, Your Honor. And subject to your rulings, I will have both of my clients available for these parties as they might be needed, subject to your subsequent rulings.
Thank you.
Thank you.
Your Honor, do you expect all jurors to be present for all 3 days?
So, let me make it very clear that I expect the jurors to be the first witnesses to be called in these proceedings. And the jurors will testify, and then they would be dismissed. They would not be required to stay for the rest of the proceedings at all. So that is very much a part of my thought about what it takes to protect their identities. They would be protected as best I can, and the ability of others to come and beset them with questions as they leave would be protected. So,
Do you expect that you could get through all 12 in one day, or should I tell them, because a couple have to take off for work?
yes, I do.
Okay, thank you.
All right. And Mr. Lewis.
Your Honor, I'll be brief. In light of your rulings, I don't think you need much from me. The only thing that I'll add is I'll have Ms. Hill available for here as the parties need him, and happy to accept service to alleviate one issue for this court. Unless you need anything from me, Your Honor.
All right. Thank you for that. And before you leave the podium, let me just consult with the lawyers. I'm not going to ask them to examine you. That wouldn't be fair at all. But I'm going to ask them if there's anything else I need to inquire of before I let you go. As I understand it, the subpoena, and we would have a formal subpoena of Ms. Hill, would be placed in your hands as her attorney. and you assure her appearance, and I appreciate that very much.
Absolutely.
Is there anything else on behalf of Mr. Murdaugh?
Your Honor, just in an effort to try to expedite this matter, I'd have two questions. One, will Ms. Hill meet with Mr. Griffin and I?
We'll evaluate that.
You'll evaluate it. Okay, that's all I can ask. And secondly, should we have her here on that Monday or wait? I mean, if you're going to be doing the jurors most of all
She should
day.
be here as court begins.
All right, thank you.
Nothing from the state, Your Honor.
All right.
Thank you, Your Honor.
I'll go over my checklist one more time, but I think I've covered everything I want to cover. I'll come to each of you in a moment. Yes, just to clarify other witnesses, as matters now stand, the witnesses in this proceeding would be jurors and Ms. Hill. So I want to be sure that we're all understanding exactly what's going on in that regard. I would not allow the attorneys to be called. I'm unclear about the mention in some of the papers that SLED investigators would be asked to testify, or any other witnesses. So I'm going to go one more time. I want to get real specific so you will understand what you need to prepare for by way of in-court examination and what you need to prepare for by way of submitting proffer. All right, first of all, for the defendant.
Police Court, Your Honor, just a couple of issues. One, we don't know who we're going to call to impeach Ms. Hill. Because we don't know what she's going to say. So it's difficult for us. I mean, once she testifies, at that point, we say we'd like to call so-and-so and so-and-so and such and such and such and such, number one. Or maybe no one. I mean, she may concede every issue we have. For instance, she did tell, according to the state, she did tell one of her assistants, one of the people helping her, I hope he's found guilty because it'll help book sales. Now,
I hope that's the last time you're going to repeat that until I ask for it again, Mr. Harpootlian. I've told you that I can't imagine a situation in which I would go that far. A statement like that, and she may well have said it, if it goes to anything I'm asked to consider, it would be to her credibility. And I'll evaluate whether I think that's even proper to ask, but let's move on from that.
but there are other questions concerning her credibility.
Yes, sir.
404 motive. If she did this, it is a crime. And so, the question to why she would have done this extraordinary act, and we can argue this at another time, but in terms of me the reason I mention it is for us to proffer those people now, not knowing what she may admit, that question may get asked, she may admit it. There's no witness that needs to be called. So it's difficult for me to game this out. I don't think I've ever been asked to list witnesses I would call to impeach somebody if they lie under oath. I've never heard of such a thing, but I will attempt to do the witnesses we would call prior to Ms. Hill's testimony. That's all I think I can do, if that makes sense.
It doesn't make complete sense to me because this is not the trial of Ms. Hill. And issues about motive and so forth and the possible commission of crimes are not what this inquiry is about. It is about her contact with any of the jurors and what she said. So I will be treading very carefully with a good deal of what you say about what you might or might not ask. But I am going to ask all the parties to be pretty specific with me about what I should be asking the jurors, and I can make a decision in advance as to what I am going to do about that, and what is going to be, at least by general topic, pursued with witnesses.
Yes, sir.
And the reason I do that is because it gives me the opportunity to then consider what rulings I would make and move the proceedings along in an orderly way.
Well, Your Honor, maybe premature for me to note this for the record, but we would accept your ruling on that.
All right.
Okay. Secondly, Mr. Murdaugh has been unable to review any of the discovered material in this case because of the confidentiality order prohibits us to distribute to him while he's in jail. We don't have time in the next less than 2 weeks to go sit down with him and review everything. Would Your Honor allow him to have them? And the materials are not as to the evidence in the underlying case, it's as to juror issues. And while he is no longer a lawyer, he was a lawyer at one point and can evaluate this and be of assistance to us if he has an opportunity to review that material.
You're speaking to me about something in a complete vacuum as far as I'm concerned, so I can't really evaluate what you haven't been able to review with him and what you have been able to review with him. As I understand what you're telling me is I have received certain information as the attorney for defendant that I have not been able to show defendant for defendant's review because of the confidentiality order. I can't imagine that. I think what you may be saying is Mr. Burke has not been able to keep for himself while I'm not there confidential materials.
That's correct.
That is something common to many folks who are under incarceration are limited in the kind of materials that they can receive and keep in their possession when they're not with their lawyer. This is not an issue where he's being deprived of the ability to consider material that you have received. This is a question of whether he can have that material in his possession when you are not there or your representatives are not there and study upon it and so forth. I can't control what the limitations of the Department of Corrections are, nor can I control what limitations may have been put on confidential material because of the fear that it would fall into other hands. So I'm not going to rule in the abstract on things. I would have to have something pretty specific, but I can tell you this. I would certainly not order that these materials be wholesale given to him for him to take back to his cell and have in his possession, because I don't know who might see them were that the case. And if they are confidential materials, that would be an extreme risk of breaching the confidentiality of materials to do that because of his situation. And his situation is as it is. Not my making or yours.
Your Honor, I would only note for the record this: much of the material we've received has been within the last 2 weeks. This hearing is scheduled for 2 weeks from yesterday.
Yes, sir.
And you've given us more stuff we have to do between now and that hearing. There's nobody to go sit with him at the jail, and his time is limited as to when those people can visit. So without him being able to review this material, I don't believe we can be effective, and we would be ineffective in representing him.
Well, I understand that those are wise statements for an attorney to make to preserve your position on the record. It doesn't change my view of how we should proceed in this matter at all. I think you will be able to, if there are deficits in what you have been able to do with your client, you will place those contentions on the record, and the appellate courts of the state will have adequate chance to review.
Well, Your Honor, would you consider continuing the hearing on the 29th to allow us to meet with the client and effectively review these materials?
No, sir.
Okay.
Thank you.
We respectfully accept your ruling.
I understand.
Thank you.
Mr. Waters?
I don't have much to address, Your Honor. The initial question that Your Honor asked was about SLED agents being listed on the potential witnesses. And, Again, Your Honor, when these allegations were first raised, we instructed SLED to do an independent investigation, good, bad, or ugly. And only because of the results of that investigation, or the reason why we're standing here and litigating these issues before Your Honor. Ultimately, the only way that SLED agents could potentially be testifying, and again, when we filed our response, we didn't know exactly the parameters the court would rule. The only way, though, that I can see them potentially testifying is in the event that there is an accepted witness by Your Honor, that there was some sort of prior inconsistent statement under Rule 613 or some other permissible inquiry. But I think Your Honor's rulings as to the nature of the inquiry we're going to conduct would probably remove or make very unlikely that need.
All right. Anything further?
Nothing from the state, Your Honor.
Nothing to defend, Your Honor.
All right. I say to attorneys for both sides, the court is deeply grateful for the very fine materials you have submitted so far. It's an extreme amount of work in a very truncated period of time, and I appreciate the burdens it places upon you, Mr. Hopkins, and I particularly thank you as a member of the General Assembly for not interposing your immunity because you are in session, and I respect that. I set these matters after consultation with y'all so that I could fulfill my obligations to the court as expressed in Chief Justice Beatty's order. But I realize that I'm doing that with your extreme cooperation in light of your other duties, and I appreciate it very much.
Thank you, Your Honor.
I look forward to further submissions from the parties and from the hearings commencing January the 29th. Court will be in recess.
Thank you.
Thank you, Your Honor.
Nice, huh? She is quite the efficient judge.
Hold on. I asked Ms. Harris before these matters commenced to please expedite, even if it's in a rough form and not in a perfect form, the court would like to produce their transcript. I asked her to produce a rough copy of the transcript just as soon as she possibly could for both sides. I hope you all will consider, without me having to order, sharing the expense of this production, this early production of the rough copy of this matter. She will be in touch with you, and you may be in touch with her with regard to the rough transcript of these proceedings. We'll be in recess.
Thank you, Your Honor.
Okay. So, she wants, like, in case you didn't get it that I said it, it's going to be written down, and you can order the transcript, like, right now, as long as you want to pay for it. I like her. I like this judge. Punchy. This is, okay, I'm going to lower this because it's just like, actually, I think I could just mute it because it is annoying as we watch. Okay. But hey, Punchy, this is Alex Murdaugh, and this was the hearing for procedure for going forward with an evidentiary hearing on whether or not a retrial is necessary for his guilty verdict for the murdering of his wife and son. Apparently, there was a court clerk who is had some problems and some reputation issues and under investigation for a bunch of stuff. And a couple of the jurors who actually did not render a verdict actually said that she said inappropriate things that may have influenced the jury. At least that's the claim of the defense. So this judge, Judge Toal, is going to speak to the jury one-on-one. She will be the one to answer all the questions, hear what they have to say on whether or not they were influenced in any way or any of this actually happened, because none of the sitting jurors have released affidavits with the defense team. The bulk of their claims are all about the dismissal of a jury and an alternate they're their witnesses. I'm glad you're safe though, Punchy. I'm glad that nothing happened when that wheel blew on your truck. I did see that picture. Well, Alex Murdaugh doesn't look in too depressed a mood after this hearing. I think it went okay for both sides. What do you guys think about Hart Pooley and not being able to bring the alternate or the dismissed juror to validate his claims? I kind of really liked. That's D.A. Wilson for the state, who is also going to be running for office, I believe. This case is very important to him. Remember, 118 charges against Alex Murdaugh for financial crimes. 90 affidavits. I mean, oh my God, charges. So many charges. And he did plead guilty to almost every single one of them. This man has got a roster on Murdaugh for sure. Well, it looks like they're all just going to be conferring now. I think that's it for this one for now. So, thank you all for joining my last minute stream to get this documented. I was going to trim off the beginning, but I don't want to lose the chat. I think you all had some valid questions and all there that others will find interesting and some information. So I will be putting timestamps and adding to the actual description. This was really makeshift. I might even actually have to make a thumbnail now since I'm going to keep it up for as long as they'll allow. But hopefully we will be covering this at the end of the month when they actually get to the trial. And as things are filed back and forth, I'll keep you updated on how they're going with the process. I do sound a little bit better, but I do feel a little congested. I do plan on coming back tonight. There's so much going on today with hearings and trials. I've got like 2 that already happened that I have to go check out. And we've got Scientology. There's the anti-SLAPP hearing, with Leah Remini versus Scientology that's going on today. E. Jean Carroll's jury selection trial started today in Manhattan with against Donald Trump for defamation. This is round 2 for them. Okay. Oh, I'll tell you. And also, Rex Harriman was charged, additional charges today. So meet me back here later tonight, everybody. We've got lots to talk about. Okay. Otherwise, have a great day. I'm gonna go get some more coffee. Bye.